How do you assess testamentary capacity? When it comes to making a will, understanding testamentary capacity is essential. This term refers to a person's legal and mental ability to create or modify a valid will. So, how do we assess this capacity? Let's break it down into clear steps. First, we look at whether the individual understands the nature and extent of their property. This means they should have a general awareness of what assets they own. It does not requiring them to know the exact value of everything, just a basic idea of their possessions. Next, we consider if the person knows who their natural beneficiaries are. These are typically close family members or dependents who would normally inherit from them. Recognizing these individuals is a key part of the assessment. Another important factor is whether the person comprehends how the will distributes their property. They should be able to explain who gets what and understand the implications of those decisions. This shows they are thinking clearly about their wishes. Finally, we need to see if the person can form a coherent plan. They should be able to connect their knowledge of their property and beneficiaries to create a logical distribution plan. This means they can articulate their intentions in a way that makes sense. In practical terms, assessing testamentary capacity often involves several steps. A legal evaluation is usually the first step. An attorney or estate planning professional will ensure the individual meets legal standards, including being of minimum age and mentally sound. If there are concerns about mental capacity, a medical or psychological assessment may be necessary. A healthcare professional can evaluate cognitive function, memory, and understanding. This can help clarify whether the person has the capacity to make a will. Observation during the will execution is also important. Witnesses and attorneys will pay close attention to the individual's demeanor, coherence, and ability to communicate their wishes clearly. This observation can provide valuable context about their mental state. Some practitioners recommend documenting the process. Recording the will signing or obtaining a statement from a doctor can support that the individual had capacity at the time of signing. This documentation can be helpful in case of future disputes. From an elder law perspective, assessing testamentary capacity is particularly vital. Older adults may experience cognitive decline or face undue influence. Ensuring they have the capacity protects their true intentions and helps prevent future conflicts over the will. In essence, assessing testamentary capacity involves confirming that the individual understands what a will is, the nature and extent of their assets, who might inherit, and how they want their estate distributed, all at the time the will is made. This assessment combines legal criteria with practical observations and, when necessary, medical evaluations to ensure the will reflects the individual's genuine wishes.